I'm going to introduce our speaker in just a moment, but I wanted you to know that we had an interest in trying to do more to prevent water contamination in southern Door County. And so we looked at what could be done, what were some more restrictive kinds of ordinances that could be passed. And it looked like that was going to be difficult to do, to be something that was more restrictive than state law. So we thought, let's bring Adam in, an expert from Midwest Environmental Advocates, who's been a great partner with us over the years. And Adam is a staff attorney at Midwest Environmental Advocates, and they are a nonprofit law center, and they have done lots of work in many different areas. And Adam has been really focusing on law related to farming and agriculture. So Adam will be covering a lot of things tonight, including the concern that many people have about whether or not a moratorium could be passed and what other options we would have to reduce expansion. So that's been a big issue here in Kewaunee County and Door County, as well as other counties that are in the heart of CAFO land. The giant expansions, regular farms becoming CAFOs. And so we're going to hear from Adam on a number of things, including the possibility for moratoriums, as well as more restrictive ordinances. So we welcome Adam, and I'm going to turn it over to him at this time.
All right. Thank you so much, Dean. Just a quick sound check. Dean, can you hear me?
Yes, I can.
Perfect. All right. As Dean kind of, I'm not going to say stole my thunder, but gave a pretty great introduction to MEA and in general what we do. Welcome everyone to local regulation of concentrated animal feeding operations. My name is Adam Voskel. I'm a staff attorney at Midwest Environmental Advocates. As Dean said, I focus a lot of my work on agriculture work, and even within that, a lot of my work is actually more the subset of agriculture, which is specifically concentrated animal feeding operations, the topic of discussion tonight. And so before we jump into content of local ordinances, moratoria, those types of things, I wanted to first give a bit of information about Midwest Environmental Advocates. As Dean said, we're a nonprofit law center. We're based in Madison, Wisconsin. And to some extent, our name is maybe a bit of a misnomer, or we had grander ideas when we were founded about 25 years ago. We primarily focus on Wisconsin. There's a lot of law and a lot of issues and concerns and great things going on the ground here. And we have plenty to do in Wisconsin. And so we focus our work on providing or protecting or rehabilitating, really focusing on healthy land, water, air, and government in the state, and working with communities. We do a lot of grassroots work. We do a lot of community lawyering, meaning that our goals are our ultimate, optimal outcomes are dictated by and driven by communities. And we're just kind of there to help provide the tools. And sometimes that's through litigation. Sometimes that's through educational webinars. Sometimes that's through advocacy. We really try to be involved in any way we can, so long as we're supporting and working with the communities. One thing that I will note that's been something that one of our staff members heard recently, I'll just highlight, we're not a member of the government. Like I said, we're a nonprofit environmental law center. We're an organization that operates largely through donations, and the folks that work with us, and maybe not work with us, but offer donations, really see us as a counterbalance, particularly to the well-funded industry center or industry like Wisconsin Manufacturers and Commerce, an entity that I feel like most of the staff attorneys, and maybe a lot of you on this call, might be quite well acquainted with, at least in name, and seeing them in a whole bunch of lawsuits related to rolling back environmental regulation and environmental protection, which is something that I'll talk about a bit later, giving a brief update into some litigation updates that and some successes that we had relatively recently. So yeah, that's a bit of our background, and I'll just jump right into talking through what I plan to discuss tonight. As Dean said, this was also the time that I had planned to mention two things. One, I can't cover everything. There's a lot there, both in terms of the opportunities for local government, but also the limitations, and even within that, recognizing that authorities or options that may be available to places like cities or towns or villages may not be the same things that places like counties can enact, and vice versa. So I tried to be as descriptive as possible. I tried to pull in a lot of the references and the similarities that I see between a lot of these different ordinances that currently exist throughout the state. But if it feels like I'm getting close to something, but maybe not touching on a specific topic that one of you or some of you may have interest in, I would really highlight what Dean said and recommend using that chat option, and just flagging a specific question. If you can pull maybe a slide title or some context to remind me as I'm talking through it later on, that would be helpful, but not entirely necessary. So any questions, there are no bad questions here. I'm happy to do my best to answer them. And if I'm unable to, I will do my best to find an answer. And if you reach back out to MEA, we've got some contact information on the at the end of the slide, or at the end of the slideshow. I'd be happy to talk about this stuff further. It is literally what I do from basically when I wake up to when I go to sleep. All right. So here's a brief overview. I plan on just starting with maybe something that's going to be basic for some of you folks, but also recognizing we don't all come into this discussion at the same place. So I want to just briefly describe, and I'll do my best to make it brief, what CAFOs are, and touch on a bit of why they're a concern, which I think will lead into some of the conversation later on local ordinances and the different opportunities available. Then I'm going to talk about some of the state permitting updates, remembering obviously that we're all here to talk about local opportunities, but I think we had some wins recently, and what's the point of having these types of calls if I can't brag just a little bit? And then I'll talk about moratoria, where we've seen them enacted, the authorities that they're relying on, the work that communities have done, the pushback that industry groups like WMC engage in, and kind of what the value of moratoria are, before jumping into 4 specific local ordinance types, maybe is a good way to say it, and then ending with some questions. Recognizing there are additional types of local ordinances that exist. For example, there are manure storage ordinances that we've seen some great ones get passed around the state even recently. And I think I saw someone on the call that worked on some of those ordinances over in Western Wisconsin. So those exist. We've got different types, different iterations of even these ordinances. So the opportunities are relatively diverse, but I'm hoping to create a foundation by which the folks on this call can elevate what they're asking their local representatives and their local governments for. And if follow-up work is needed, like I said, MEA is always happy to take calls and work with folks to assist where we can and support where we can in really upping the regulatory authority of local governments. All right, that was enough of a preamble. So concentrated animal feeding operations, what are they? I imagine people don't give up a Tuesday night without having some basic knowledge of this, but just as a bit of background, we're talking about typically thousands of animals confined together. Technically, for milking cows, it's actually 700 milking cows. 715 is the threshold to be what qualifies as a large concentrated animal feeding operation under state and federal codes. And why we're so concerned about them is because concentrated animal feeding operations produce an absurd amount of waste, right? This is untreated manure and processed wastewater that is just commingled. I'm sure some of you have seen the quotes that it's the size of medium-sized cities, the same amount of waste is generated annually, hundreds of thousands to millions of gallons of liquid waste. And that waste is stored in manure lagoons, which you can see on both of these screens, or both of these images on the screen. They're just, for the most part, typically open pits. They may be earthen lined, they may be clay lined, they may be concrete lined, but they are just pits that sit in the ground. The manure is stored there until it is eventually spread on typically the fields as close to the operations as possible. We saw some studies come out in the last couple of years now that basically said more often than not, manure and waste is spread within 1 mile of where it's produced. And so if you're thinking about millions of gallons of manure being spread in such a condensed area, you're just kind of, you're set up to fail. You're set up to cause some type of water contamination or other environmental concerns. And because CAFOs store that manure in that way, because they spread it in that way, because they produce so much waste in that way, they are defined under both federal code and state code as point sources. Historically, when the Federal Clean Water Act was passed in was that 78 in the 70s, the general concept, or what people maybe thought of what a point source was like the end of a pipe. But we also know that because of the way these entities operate and because of the way that they manage their waste, they effectively serve in that same way as a discrete place where you see a discharge to a water, whether it's surface or groundwater. So because of the amount of waste they generate, they are regulated by the state. And I realize we're talking about local stuff, but I think it's important to at least recognize the base level of where regulation occurs for these entities. And why do we care about it? Again, I imagine most of the people on this call are from the kind of northeast section of the state, the Door County, Brown, Kewaunee, Manitowoc. But certainly I saw names that I recognized on this call that are from other areas of the state. There has been a consistent growth of CAFOs over the last 20 to 30 years. I think every year I have this slide that exists in kind of stasis on my presentations, and every year or every few months when I give one of these, I have to re-update that number on the bottom. I can tell you that before today, this slide said 327 CAFOs because that's what it was last fall. So they're continuing to grow. We're continuing to see consolidation. We're continuing to see a loss of smaller family farms and a growth into concentrated animal feeding operations. And when you look at that map on the right, you'll notice that they are not equally divided across the state. They are consolidated into specific areas. And unfortunately, those areas also tend to be the areas that have some of the most susceptible landscapes or geology to create groundwater concerns. So up in northeast Wisconsin, in Door, in Kewaunee, in Brown, the 15 counties in that eastern section, east to northeast, we see karst topography. Silurian dolomite is the scientific name. That's characterized by really shallow depth to bedrock, fractures, sinkholes, basically creating direct links to groundwater from surface activity. So we've seen a lot of groundwater contamination there. You go along the southwest to western portion of the state, similarly, you're going to see not the same karst topography, but a similar karstic system where, again, there is a susceptibility to groundwater contamination that just exists. And even in the middle of the state where you might think, oh, there's not karst here, instead what you see is sandy soils that create almost this perfect system to allow for transport to groundwater. So all that to say, there's not like a safe place where 10 to 20 to 30 CAFOs can just exist in close proximity and not have an adverse effect on resources, whether that be air resources, groundwater resources, surface water resources, and certainly effects on neighboring communities and downstream or downgrading individuals or households. And that kind of encapsulates what this slide was talking about, right? And For CAFOs, what we see in drinking water contamination based on their discharges from their manure lagoons, as well as their discharges that just kind of transport down from fields, we see things like nitrate and bacterial contamination leading to things like blue baby syndrome, E. coli contamination, thyroid and colon cancers. Historically, exceedances of nitrates had often been thought of as like particularly or focused on pregnant women or newborns, but we're seeing more and more data come out that really indicate that it's broader than that, that there is a broader concern that exceedances of the safe drinking water standard is 10 milligrams per liter in drinking water essentially, but we're seeing stuff as low as 2 milligrams per liter having kind of adverse effects on statistically significant populations. Surface water degradation, folks that live in Northeast Wisconsin may recognize things like phosphorus exceedances in Green Bay, and now even the Northeast Lakeshore on the other side in Lake Michigan. We see surface water exceedances, particularly from phosphorus from non-point runoff from fields, lead to algal blooms, to fish kills, to low oxygen in the water. Again, a really significant threat to local communities, whether it's threats on health-based issues or threats to things like tourism and property values. Air quality ties, I'm not going to focus too much, but there are some local ordinances that we've seen pop up recently that have addressed air quality concerns, or at least touched on air quality concerns. And that's because CAFOs are known to emit significant amounts of hydrogen sulfide and ammonia. And those two emission gases have essentially been tied to things like mental health concerns, significant health effects, including migraines, headaches, almost mood swings, and just depression, and not based on just being adjacent to it, but actually chemical changes in the brain. Excuse me. Finally, a couple of other things that we've seen some local ordinances try to touch on or actually touch on, but in different ways. We've seen diminished property values. Those are usually tied to nitrate exceedances. We've seen direct ties to nitrate contamination in private drinking water wells lead to a depreciation in property value. And once that's resolved, that property value jumps back up. So they've been able to show that correlation there. Or actually causation. I didn't take stats in college, clearly. And then finally, increased truck traffic. You see these dozens to hundreds of trucks, manure-laden, heavy trucks with thick, aggressive tires driving down roads that don't have the capability of being serviced as often as they should be if there's going to be that type of traffic. And that leads to a degradation, and that affects the communities, it affects people's cars, it affects transit times, and there are a lot of kind of ripple effects just as a result of increased traffic that I don't know that necessarily ever reaches the headline of news, but is certainly one of the things that I hear about quite a bit when folks are calling MEA and I'm working with them on potential issues. So how are CAFOs regulated? We're going to spend a lot of time today talking about that last bubble, squarish bubble, that local opportunities, the local zoning, local ordinances. But I think it's important to note that they're addressed or they're at least regulated by in a couple different ways. The Federal Clean Water Act does define concentrated animal feeding operations as a point source. That's kind of the base level. However, the EPA in Wisconsin does not regulate CAFOs, and that's because Wisconsin was delegated essentially EPA's authority under the Clean Water Act to behave as EPA under their own program. And that's called the WIPDES program. As you can see, that top arrow from state, the Wisconsin Pollution Discharge Elimination System program, or Wisconsin Pollutant Discharge Elimination System. And the interesting thing about that is while that encapsulates all of EPA's authority, Wisconsin actually went a bit further. And so what we see is that Wisconsin defined a really specific term, waters of the state, to include things like groundwater. And that's a really important concept because at the federal level, they don't cover groundwater. The EPA doesn't regulate groundwater in the same way. And so CAFOs are only regulated insofar as they discharge, they have an intentional release of pollutants to surface water. And that's sometimes hard to show or hard to prove. Not so hard to show that CAFOs, by sheer act of existing, essentially are discharging to groundwater. And so as a result, whereas the federal government is relatively limited and they don't permit or require all large CAFOs to seek permits, the Wisconsin DNR does require all large CAFOs, all CAFOs with 1,000 animal units or more, to apply for a permit in order to operate. So what that's maintained in, as you can see in like the small subtext of the WIPD's arrow, that requirement is enshrined in Wisconsin Administrative Code NR 243. And I'll just note at the end of this, I'd be happy to make my slides available. I'm an attorney, so I do a lot of citation work. I realize that may not be relevant to everyone, but to the extent some of you are interested in it, I'm happy to share the slides. NR 243 has a redirect that also says CAFOs have to manage their manure in a specific way, and that is in NR 151. And so the state basically maintains or enshrines two specific requirements for CAFOs in NR 243 and NR 151. Those work together in a way that is meant to address surface water and groundwater contamination, or at least discharges. I'll note, as many of you on the call may know, it's not a perfect system. I certainly have quoted the line in the discussion of groundwater or nutrient management plans, that nutrient management plans are not intended to prohibit discharge to groundwater, but just essentially regulate the discharge to groundwater. So even NR 151 meeting those standards doesn't necessarily mean that, you know, the groundwater is inherently safe. And as a result, we've seen additional permit terms, additional requirements come through in recent years in an attempt to try to protect groundwater with, you know, I would say mixed results. So let's really briefly talk about WIPD's permits. And I might even skip this slide, just recognizing where we're at with time. And because I just covered the information, and instead talk about some of the litigation developments. Like I said, the federal government doesn't necessarily regulate CAFOs in the same way that Wisconsin does. And that's because that the definition of waters of the United States are navigable waters, in fact, they are surface waters, whereas the definition of waters of the state includes groundwater as well. Despite that distinction, but despite that difference, in May last year, Wisconsin Manufacturers and Commerce, like I noted, an industry group that has more and more actually spent a significant portion of their, I would say, time and money working on CAFO and agriculture related issues, filed a lawsuit in Calumet County, basically asking a judge in Calumet County to say that the DNR could not require concentrated animal feeding operations to apply for a permit, to hold a permit. They cited two cases from 2005 and 2011. We in the industry, we call them the water keeper case and the pork producers case. And they basically said, because those cases from unrelated districts across the United States said that EPA couldn't require CAFOs to seek a permit before operating, because those courts found that this court and Wisconsin in general could not be allowed to regulate CAFOs in a different way. That case went largely, at least initially, under the radar. It was filed in May. I don't know that anyone heard about it for a month and a half. But the Department of Justice representing the DNR filed an answer in July. And in August, MEA representing Wisconsin Farmers Union and then Clean Wisconsin moved to intervene in that case based on the concerns of, in Clean Wisconsin's case, their members, and in Wisconsin Farmers Union case, their members, who are family farms that are dealing with oftentimes potentially neighbors that are CAFO operators, and also that are affected by the regulation of CAFOs currently. I think there's a collective understanding that the current regulatory system isn't perfect, but the potential outcome, if WMC would have won, would have essentially deregulated CAFOs in the state. They would have not been required to hold any permit really before or as they operated. So I worked representing Wisconsin Farmers Union. We filed briefing throughout the fall and into the new year. And then about, I think exactly 2 weeks ago, on January 30th, there was oral argument that was held virtually in front of the judge in Calumet County. We prepared to talk about the deficiencies of WMC's case. They were representing Wisconsin Dairy Alliance and Venture Dairy Cooperative, of which there were a lot of deficiencies. There were questions about whether or not, you know, they had standing to bring the case, whether they were actually injured by the regulations at issue. But we were also prepared to talk about the content of the case, the merits of their case, the fact that Wisconsin DNR is authorized, and more than that, like directed to regulate in this way because of the way our system is set up here. I'll be as frank as I can be on a call with 36 strangers. We went into that not necessarily expecting that we were going to receive an outcome that day, right? There are a lot of different issues in a case. I had at that point, along with Clean Wisconsin, we'd filed probably something like 200 pages of briefing on the merits and issues just as interveners alone. That doesn't take into account WMC's briefs and DOJ's briefs. And so there were a lot of concepts at play, a lot of issues at play. But after an hour of oral argument, the judge just started explaining his thinking. And about 2 sentences in, I wrote on my notepad next to me, "I think we won." And it took all of 5 minutes of him ruling for him to say, you know, the law as it's been defined based on a 2002 lawsuit that was at the Wisconsin Court of Appeals that we call Maple Leaf Farms, as well as the requirements enshrined in Wisconsin Statutes 283 and Wisconsin Statutes 160, and to a lesser extent, Wisconsin Statutes 281, all direct the DNR to require that CAFOs have permits. And I don't see anything in the law that says that they can't do this. And actually, I, come to the opposite conclusion, that they are appropriately authorized to do this. So that ruling was in our favor. It was not a surprise that we won. I will be the first to say I felt very confident that we had the best side of that case. But it was a surprise to receive that favorable ruling on that day. We're now waiting to see whether or not an appeal comes down the pipe based on cases or statutory requirements, civil procedure in Wisconsin. That appeal would likely be filed March 15th, right around the Ides of March. And so I'm sure folks will see news if it happens. I can't even be certain that I can say when it happens. But if it happens, I'm sure MEA will be will post it out there. It'll make news. CWEC Dean may also post about it as well, because it's a big deal, and the potential adverse effects of an adverse decision can't really be understated. So it was a great win at the circuit court level, and now we're just waiting to see if more work is needed, or if they'll take their lumps and essentially understand that it was a losing argument from the start. All right, now to why you're all here. Brief aside, maybe less brief than it should have been. So I want to start with CAFO moratoria, and I organized the presentation this way because typically this is the timeline of events for regulation in a specific way. That's not to say that it's always the timeline, but what I typically experience when folks call me in from around the state, and it's becoming less and less often that I guess this timeline exists, but people in an area that, in a county that hasn't had a CAFO before, or a town that hasn't had a CAFO before, suddenly catch wind of an operation looking to site there. They may have filed an application with the Department of Natural Resources. They may be reaching out to landowners in the area asking for agreements to spread on fields. And so the first step is like, whoa, 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 we need to take a step back. We need to figure out what we're doing, and we need time to do that. Things are moving. We're already behind the 8 ball. Things are moving a little faster than we would like. And as a result, the first thing that they ask, is how do we give ourselves time? And to that, my response is always, we've seen CAFO moratoria work in the past as just something that gives pause, that gives the local government and the residents there an opportunity to think about their options. So what is a CAFO moratorium? Or a CAFO moratorium, the singular. It's a pause on the development of certain facilities or land uses within a jurisdiction, right? So if a town passes a CAFO moratorium, it doesn't mean that the adjacent town a CAFO can't site in. It's specific to the boundaries of that jurisdiction, but it basically says you can't operate, you can't develop in this space at this time. For CAFOs, we're talking about an authority that isn't dictated in Wisconsin statutes. There isn't a black letter line that says, a county may pass a CAFO moratorium. What it is it's a recitation or a citation to a collection of authorities, typically focused on the protection of health and human safety. And as a result of that, in addition to relying on what I call those home rule authorities, there's also a need to rely on some case law, some Wisconsin case law, some persuasive case law from other states that basically indicates that that type of regulatory action, that type of CAFO moratorium, is lawful so long as it is temporary. It needs to be of reasonable length. And so that's meant different things to different local governments. For example, I've seen 18-month moratoria. I've seen 12-month with an option. They reserve the right that after 12 months, if they need more time, they can pass an extension of that moratorium. So for an additional 12 months, I've seen 6-month moratoria. I've seen 18-month moratoria that after 9 months are rescinded, either because the work wasn't being done or the local government just opted to move a different direction. I will note, I think I bring this up a bit later on, moratoria are really driven by the community making demands of their local government to engage with the issues, to act. Rarely do I see like a town board or a county board independently come to the conclusion that they're going to behave a certain way. It is built on community activism. All right. So what are some of the considerations for CAFO moratorium? Timing, I think, is a really big one. There's this concept in Wisconsin called the building permit rule. It started off as a decision at the Supreme Court in 2015, but has since been enshrined in statute, and basically says, this is for the timing for this instance is important for new or proposed CAFOs. Basically indicates that an entity gets what's called vested rights. So basically they set the law, they make it set in stone based on when they submit a complete application to the local government, outlining essentially their proposal. When they do that, assuming that it complies with all laws at that moment, all the laws are set in stone at that time. And so that's one of the values of a moratorium, right? If they can't submit that application, they can't set the laws in stone because there's a pause on what they can do in that moment. So you give yourself 18 months to establish, or 12 months, an additional 12 months, or 6 months to establish what the laws that they'll need to comply with are. And they don't get to have their rights vest back in time to a different set of laws, laws that hadn't been written as if a concentrated animal feeding operation were about to exist in the community. So that's one of the most important things when I'm confronted with a proposed CAFO, a new CAFO in an area. I'm thinking of, and someone's asking like, well, can we pass a moratorium? I'm trying to think of applicability, right? Who will this apply to? And the first thing is if it's a new one, it's like, well, have they submitted their applications? You need to think about that. And if they haven't, you need to act quickly, because I can tell you I'm not the only person that's aware of that kind of timing limitation. And so getting the local governments to respond a bit more quickly may be valuable. Similarly, not just with new or proposed CAFOs for existing operations, that's an additional consideration. Certainly, you could put a limitation or a moratorium on expansions during a time. And then, if you're seeing an existing CAFO that obviously at that point has certain laws set in stone, you may be considering additional laws that they would need to comply with in the future, pending an expansion or building a second operation, things like that. But who this moratorium will apply to is one of the most important things, and fashioning it in a way to capture the correct concern is something that takes, I'm not going to be able to answer it holistically for everyone on this call, because it's not one answer. It requires a bit of noodling with language and really thinking about how you fashion something. So I would say, again, my contact information is at the end of this. If we're talking about, or you would like to talk more about, how do I get this moratorium to do what I want it to do? I'm obvious I can't give you the answer. I can't do legal work for you, but I'm happy to talk through that question a bit more, because like I said, it's very specific to the individual, the location, things like that. And then I kind of got into this earlier, but process, that's something that's specific for different governments. I can't even say it's specific between counties and towns. It could be different between one town and the next town because of internal procedures and processes. So again, if you're considering working with a county, you're going to need to check the county ordinances on passage of a moratorium. Sometimes it comes from the planning and zoning department. Sometimes it comes from the land and conservation department. Typically, county boards can, in Latin, sua sponte, so independently, the board chair can add it to an agenda where the whole board could address it, even if lower committees haven't. Towns don't usually have the same amount of bureaucracy, but they may. And so I just note that, again, you're just going to have to think about that stuff. You're going to have to know who to ask what for going into this. And unfortunately, I feel like one of the typical go-to comments that I have to have about CAFOs is that, unfortunately, like, no one else does the work for you. The town board, the county board, oftentimes even the DNR doesn't do that work for you. It's on us to be the scientist, the local corporation counsel or staff attorney, the advocate, as well as the organizer, right? Like, you have to wear a lot of different hats to do this. So I mean, it's there to support you in it, but it does require a bit of legwork to figure out what applies and what processes are necessary. All right. So what is accomplished in a moratorium? And I included this public opinion poll, which came out in 2015. I believe it was based up in Bayfield County, where there was a proposed CAFO that was going to be sited somewhere between 1 and 2 miles from Lake Superior, which is just a, forgive my language, wildly stupid place to site a concentrated animal feeding operation in that type of region. And it ultimately didn't pass because of the work that was done at the county level, the advocacy that was done with the residents there, both to the county as well as to the DNR. The DNR opted to require that the CAFO complete an environmental impact statement, this analysis of their effect on should the CAFO occur on the environment. And it was so burdensome, and I probably imagine that it was written so clear, like spelled out so clearly to the CAFO, that they were not going to be able to exist there as they were aggregating the environmental data that they just gave up on the project. They didn't even inform DNR that they were withdrawing their application. They just stopped submitting things to the department. So that's the benefit of like a moratorium mixed with a potentially restrictive local ordinance mixed with DNR advocacy, right? Like it's a, you have to have this holistic response. So what can be accomplished? More time, right? That's the baseline purpose of a moratorium. That is months of time to get your legs underneath you, to figure out what your next step is, to start making demands for the local government, or for the local government to start to catch up and be like, what can we do? They just, you know, we need to be persuaded. But what comes out of that more time? Oftentimes it's potential new ordinances. You know, for example, recently in Polk and Burnett County in Western Wisconsin, we saw initially county moratoria exist. And then I believe there was also town moratoria as well, though some people on this call may disabuse me of that memory. But ultimately, there was a push for intergovernmental cooperation there and to create new ordinances. They in Western Wisconsin in originally five, I think, and then four towns enacted operations ordinances, something that I'll talk about later tonight. In Crawford County, we saw a county-wide moratorium as they considered what could we pass? You know, what the whole suite is open to us. What, you know, what types of options do we have and what should we pass? I was working with a community group there on that. And there are innumerable other places, other towns, other cities, other villages, other counties across the state that basically their starting point is we're going to take 18 months and we're going to create a CAFO study work group. And that study work group is going to come back to us with the data that's applicable to our county, whether that's hyper specific regional data or just kind of broader analyses of particular environmental susceptibility that's applicable. And they'll say, like, we need a water quality protection ordinance that does this, or we need a a limitation on spray irrigation for this reason, right? Like it's finding novel ways to regulate based on the authorities granted to you in a few different statutes. There's also the opportunity of amending current ordinances. Particularly, I see that for things like livestock sighting, which I believe is like starts our conversation 3 slides from now. Basically, there are specific requirements to make stringent standards in livestock sighting, and a lot of counties that have CAFOs currently have livestock sighting. So they go, can we amend what we have? Can we just kind of fold in some new concepts to better regulate rather than creating an entirely new program? So those are kind of the governmental responses to a moratorium, what can be accomplished. There's also the community responses, which I kind of put in a separate bucket, which is to note that it's an opportunity. You've got 12 months, you can create that coalition, right? Maybe it started with 5, 10 people being very persuasive. It can end with 50 people, 100 people, collective action, packing town boards, packing county boards, making decisions that are adverse to the community's interest really difficult. You know, I've seen more than once a county board or a town board be like, you can tell they may not want to pass the thing that's in front of them, but the community is there in force, and they're just not going to make a decision the other way. And that I truly attest that it's the collective action, and oftentimes it's the collective action that was a result of advocacy and grassroots advocacy in particular that occurred during the time of a moratorium. And then additionally, and this is somewhat based on state work, but it gives time for document review. CAFOs over a period of time have to submit information to the DNR just to be permitted, and that information exists online. We have a CAFO guide on our website, and I think we have an old, like a 1-year-old CAFO webinar on our YouTube. And both of those, I talk through where you can find relevant data and information. And I would encourage anyone that's looking to kind of jump into the CAFO work to start pulling data, pulling that information, pulling those documents and review them as early as possible when they exist online, because you're going to be you're very quickly you'll realize you are the informational expert. You'll be the person that spots inconsistencies or maybe not accurate statements, whether intentionally or unintentionally, that come up at town board meetings or county board meetings. You can say no, they're going to generate 200,000 gallons of liquid waste, and they currently have 500 acres of field to spread it on. We have to do something before this goes in, right? And that the only way that you can make those claims, that you can engage in the work that essentially is potentially kind of the shift, to make the county boards or the town boards listen to you, is by doing that document review. So those last two, the collective action and the document review, they're not necessarily the things that are directly an outcome of a moratorium, but I think it's an outcome of having more time and being able to get your feet under you. And I wouldn't be doing my job if I didn't highlight those. All right. So you get a moratorium, or at the very least, you get a moratorium on a town board or a county board agenda. What happens next? Well, the first thing that typically happens is WMC and Wisconsin Dairy Alliance and Venture Dairy Cooperative and a couple other entities, they're usually all the same, send a letter. It basically is a form letter. I think I have like 4 copies of it on our shared work drive cloud. That basically indicates that a county can't, or a local government can't do what they're doing by passing a moratorium. They cite a really specific provision or a sentence in a state Supreme Court case. The case is Adams v. Livestock Facility Siting Review Board. And they say that the legislature took all this power away from local governments. I've had to respond to this question on the fly in county board meetings. The basic answer is that sentence does not dictate what this local government is doing, right? That sentence, that entire case is about a very specific issue related to livestock siting permits and whether the local government can add additional terms to those permits. It has nothing to do with moratoria. That doesn't stop these entities from sending letters. And typically, as a result, when a moratorium is passed or is being considered and that letter comes on the floor, they typically will have right next to it an MEA letter that basically explains this first letter is not accurate, right? They're not telling you what you actually need to know. Here's what you need to know. So I am really proud of the work that we've done, supporting local governments, supporting the individuals demanding moratoria. And I would say that anyone working to pass a moratorium should keep MEA in the loop, because I guarantee you one of those letters from WMC or WDA is going to come make its way to one of your local officials, and I will gladly respond to it. So yeah, just keep us in the loop. And that gets me to the history of success, which is part of the thing that we point out to local governments, which I think I have another slide for it. Yes, perfect. So they threaten litigation. They say, you can't do this, we're going to sue you. And then I say, in addition to the authorities that they're clearly granted, let me point you to this handful of more than a handful of counties and towns that have all passed moratoria in recent years. We go back as far as 2012, we go up to 2020. There may have been ones past 2021 to present. I just don't have them on our SharePoint, on our cloud storage. But all that to say, a number of these entities received threats of litigation. To date, as it relates to moratoria, I don't believe any have been filed. The only one that I wouldn't be sure about was I wasn't around in 2012 to tell you, well, I was around. I wasn't working at MEA in 2012 to tell you whether or not Saratoga or Lincoln actually had anything filed against them. My expectation would be no, but I can at least speak to 2015, 2016 and beyond. And so if they want legal evidence, I'm happy to provide that. If they want anecdotal evidence of past precedent, I'm also happy to provide that, which is to say there's a lot of reasons that moratoria can and should be passed. And there's a lot of uh, uh, justifications given by the opposing side that try to dissuade local governments from passing it that I think should fall on deaf ears. And I'm pretty vocal with that belief to local governments. I think that concludes the moratoria section. I'm not sure if there are any questions in the chat, if people have any specific moratoria questions. I think it's a great first step. It doesn't exist on its own, right? It leads into additional work, as I think I've tried to highlight. But if anyone has any questions related to moratoria, let's see. I'm not seeing any specific to moratoria, so I'm going to go on. There are a couple of questions in the chat. I will try to get to those at the end, pending time. But I'll move forward to the specific ordinances. So these are the local ordinances I decided to highlight tonight. We have livestock facility siting. It is kind of the default standard, the first step for a lot of local governments into regulating or addressing CAFOs. And then we have some maybe a bit more novel, maybe a bit more interesting, certainly a bit more diverse and less structured than livestock facility siting opportunities that I at least have seen. And this isn't to say that this is a holistic list. I saw a comment in the chat related to trucks. I've done some work on manure truck regulation. It's been typically focused through weight limits and highways. But once you get off of highway regulation, there's like some strange preemption law that I would need to, I can't adequately answer it tonight. I'll just note that there has been some attempt, or at least some work and research done into how one can regulate manure trucks. And I'm happy to discuss more about it potentially on a later date. I just don't have it here tonight. But in addition to manure truck regulation, we've also seen manure storage regulation and a collection of kind of other less often used, but tossed around in brainstorm sessions, regulations, local ordinances. But again, these are the ones I decided to focus on. So I know that livestock facility siting wasn't the thing that I was brought here to talk about, but I think it's important for folks to at least understand what it is, where it comes from, and maybe its opportunities, right? So livestock facility siting was passed in 2004. It's been around a really long time. Its purpose was to create uniform regulation for livestock facilities. Now, I think I may disagree with the typical definition that that our agencies have of what a livestock facility is. They tend to focus on things like nutrient management and manure spreading. I would argue that neither of those are facilities, but livestock facility siting addresses the location of manure storage facilities, barns and confinement structures. It creates setbacks from roads, has air emissions requirements, things like fans in buildings, and also has nutrient management requirements and spreading requirements. Those are typically the five that I think through. That air emissions one also includes odor as a question, but it's confined to those specific issues. It is essentially an opt-in ordinance. The Department of Agriculture, Trade, and Consumer Protection establishes a default standard. So it exists in Wisconsin Administrative Code, section ATCP 51. And it almost reads like an ordinance unto itself. And DATCAP also maintains model ordinances that can be adopted. So they say basically, this is what you can do. Local government, you can opt in, and these are your options, and these are your opportunities. And then you can't disapprove or say no to a permit once you opt in, unless you find a failure on any one of those five particular issues. I think that even with its limitations, if a local government has nothing, I think it's still a decent starting place. I would not say that the end of a moratorium should just lead to default standards of livestock facility siting. But if the start of a moratorium is nothing and the end of a moratorium includes among a suite of options also livestock siting, I don't know that you would say that one should, disapprove that as an opportunity, right? It gives the local government an option to say, an option to review documents and to say yes or no, where before they had no real opportunity to weigh in. All right. So with that in mind, here's what we have for livestock sighting across the state currently. Like I said, it's opt-in, which means it's not uniform across the state. So I've divided between blue. I didn't divide. This is DATCAP's map, but they divided between blue and yellow, where yellow is licensing and blue is zoning, which is just to say that local governments have multiple ways that they can regulate CAFOs. And I think in addition to just showing that like where CAFOs exist, you tend to see ordinances in some way, shape, or form. The other important thing to highlight is that zoning and licensing do different things, though they sometimes seem similar. We have some state case law, some state Supreme Court law that says that local governments have the ability, even if zoning exists at the county level, towns can license in a different way. And so I try to be cognizant of that when thinking about the ways in which a local government can regulate beyond. Maybe it starts with livestock facility siting. Maybe they want to pass it as a zoning requirement, and then they pass a licensing ordinance as well in a different way. But just to note, like, you remember that map at the beginning where all the CAFOs existed? It was like, oh wow, northeast portion of the state, a lot of CAFOs. You see kind of that line of CAFOs that exist, Kewaunee and at least Manitowoc. Brown, you've got some townships, and then you go Calumet, Fond du Lac, Winnebago, CAFO, a lot of CAFOs exist there, and the governments there have decided to regulate in at least some way. Right. Not going to spend too much time on livestock facility siting, but just wanted to highlight this one thing. Like I said, they're default ordinances, but that shouldn't stop folks from saying, hey, if you're gonna do livestock siting, what if you consider doing more? Because in statute and in the administrative code, there are provisions that allow for more strict regulation. Again, this is of livestock facilities. So, it may be the location of a specific facility. It may be a number of things. I'd be happy to talk more about it, but those additional more stringent requirements, the limitations are have created a bar that very few local governments have opted to use, mainly because of industry pushback. But an ordinance that is more strict than that default standard needs to be, and this is a quote, reasonable and scientifically defensible findings of fact. So you've got that one requirement, and that finding of fact, or those findings of fact, must clearly show that the more stringent requirement is, and this is again a quote, necessary to protect public health and safety. And so that kind of two-pronged test, almost the reasonable and scientifically defensible and necessary to protect public safety, has created just enough like gray area where local governments, particularly following pushback from WMC and WDA, have said like, well, we don't know what a scientifically defensible finding of fact means. Is it that it needs to be a peer-reviewed study that we pay for, that we pay UW-Madison to come out and do? Or can it be applicable studies from anywhere, because we have karst topography and we're not the only place in the world with karst topography, so can we kind of sweep in karst studies from other areas, just as one example. And then secondarily, what is necessary to protect public health? Like where does that bar land? And so that gray area has, in and of itself, because of industry pushback, led to a lot of local governments opting not to engage in this type of analysis, which is why I say maybe it's valuable to, if you don't have livestock siting, do this, but then also look to other options as well. Just a potential there. The nice thing about this is, short of someone immediately filing a lawsuit against the local government, you don't have to submit this for DATCAP approval. As you'll see with some of the other local ordinance requirements, a more stringent standard requires an agency approval, and you don't know what that agency is going to say when you send it in or when you get it back. So at least here, you kind of get to set the playing field and wait to see if someone wants to challenge it, versus this third party weighing in before it becomes enforceable. All right, seeing a couple questions, and I just want to double check that I'm not, yeah. So this is the end of the livestock facility siting. Let's see. EIS requirements, I'll cover it. I'll be happy to cover at the end. Ooh, that's a lot of words. I will get to those later, just to make sure that we have some time to get through this, recognizing I'm moving maybe a bit slower than I would like. Apologies for not getting to your questions as we're going, but I will do my best. I'm sorry. So, resource management practices ordinance, right? We're switching gear. We're outside of livestock facility siting. Now we're into local regulations through a different scheme. Instead of Wisconsin Statutes 9390, we have gone backwards one, and we are in Wisconsin Statutes 92.11, which is in the Land and Conservation Standards statute. It is typically the thing that a lot of land conservation departments are, it's where they're authorized for all of their authority. And 92.11 notes that a political subdivision can enact ordinances for the regulation of land use, land management, and pollutant practices. That's a quote from that section. It's important to note that that's, I would argue, relatively vague. I haven't seen that many ordinances across the state reference this section. I'll note one right in the next slide after this. But it's not necessarily clear how this differs from, the limitations or the what this covers that something like a Wisconsin Statutes 92.15 covers, or an operations ordinance. Like, uh, you know, land management and pollutant management practices seems to fall in line with NR 151, but that's covered in a different section entirely. So all that to say, I wonder if the vagaries of what this is meant to cover has ultimately led to it not necessarily being relied on as often. There is a necessary procedure for adoption here, which is that if a local government, particularly a county, this is based on county authority, if a county wants to rely on this, they have to pass it through a referendum of all the local towns. So this would become applicable within the bounds of a county, the incorporated areas and the unincorporated areas, but only in the incorporated areas insofar as those towns passed a referendum essentially opting into it. I don't know if I wrote down in my notes the exact language, but all that to note that it specifically requires a referendum if one is to rely on this section. But once it's opted into, it's applicable in that entire county, and the oversight and the enforcement authority is enshrined into or covered by the county conservationist. So that was kind of vague, right? Let's maybe get an example of it so we can think through it maybe a bit more specifically. And so the best example that I could come up with, which is the only example I could come up with, was Kewaunee County Ordinance Chapter 30. And just because I was losing some of the visuals from earlier slides, I included language from NR 151, which is the limitations on spreading on Silurian dolomite generally on the right. It's not necessarily applicable here, but I just as a comparison, maybe I included it. So chapter 30 prohibits mechanical winter spreading, mechanical application on fields from January 1st to April 15th. Now for CAFOs under NR 243, I want to say, and don't quote me on this because it's been a few weeks to a couple months since I looked at this provision of NR 243, but the high risk runoff period limitations for spreading liquid manure on fields is February 1st to March 31st, I believe. And so that would be the risk of the limitations on spreading on frozen or snow covered fields. There's just an assumption that those are frozen or snow covered fields, and so for those 2 months, February, March, you cannot spread. This extends that 15 days past March and 31 days earlier than February. And the limitation is for 0 to 20 feet of shallow depth to bedrock. So you can see that basically covers all of the potential Silurian dolomite that would be covered in NR 151 that has different restrictions throughout the entire year. They say that during those specific 3.5 months, no spreading can occur. That may become particularly useful during times where you see a lot of temperature fluctuations, where like what happens if April 1st rolls around or early January, you get one of those days where it's like 60 degrees and the snow melts and the CAFO operator walks out and like the snow seems to be gone because it's been a light year, and they can say that like the top 1 inch of soil or something is you know, a lot of standards say more than just the top 1 inch, but it's all discretionary, right? But the top small amount of soil is thawed, and so they decide that they can spread on a certain field, that the high risk has been avoided or abated. This sets a wholesale restriction. And so, you know, I think that there is occasional that there's value to that. I've heard anecdotally, right, that individuals, CAFO operators in other areas have complained about the restrictions that this causes, the limitations that this causes. But I think that its potential benefit, particularly as warming occurs and maybe runoff periods and risk periods and like strange wet periods where you're seeing freezing and thawing and a lot of precipitation, just as we get to a more chaotic world in as a result of things like climate change, just wholesale restrictions may have a value. And so, like I said, this is the only instance that I know of where 9211 was cited. That's the exclusive authority for Kewaunee County Ordinance Chapter 30. And the procedural burden is admittedly high, right? They can pass it at the county level. There is no telling which towns will opt in. I think Kewaunee had a significant number of towns opt in, but that's not to say that that would happen anywhere else. So I recognize the limitations. I also recognize that I don't know if this could be achieved in a different way that didn't go through 9211, but it may be something to consider. So I briefly touched on it. I apologize. It's a bit, it's almost out of the blue only because it's so rarely used, but I think it should be looked at a bit more in terms of limitations and protections. This is focused on surface water and land use actions, but potentially it has an opportunity to be extended beyond. So for folks that are interested in this, I'd be happy to talk more about it later if there's a specific question. But again, because of the lack of consistent use or consistent reliance on this, there's just not a lot of information. There's not a lot of guidance. There's not a lot of case law on it. It exists, and to my knowledge, it has one anecdotal use. So, given that I touched on it, but I'm not necessarily the most up to speed on it. I didn't spend too much time on it, and so we'll move on to water quality standards, which are enshrined in Wisconsin Statutes 92.15, just 4 sections further down. And those are standards that allow for incorporation of NR 151, those manure spreading requirements, but additionally exceedance, you can get more stringent than NR 151 by going through Wisconsin Statutes 92, Chapter 92.15. However, this, like 92.11, has a procedural burden, which is that those more strict standards need to be necessary to achieve water quality. And you have to, let's see what my next slide is. Yeah, so you have to receive DNR or DATCAP approval just to pass them. So 9211 had the administrative burden of referenda across the county essentially to be incorporated. 92.15 has a different burden. It's not that towns opt in, but you have to justify the standard, the requirement in 92.15 to the department, to either DNR or DATCAP. They both have standards for review, and you essentially just get to choose which of the two you'd like to speak to go through. But like I said, you submit the supporting documentation. You have to tie it into meeting or more stringent standards to protect specific water quality, and then you just send it off. And you're not no one can be entirely sure what the ultimate response is, what result you'll get back, whether they'll redline edit things, whether they'll just wholesale say absolutely not, whether they'll support it. Certainly, if you get a full-throated approval from DNR or DATCAP, I think a local government has insulated themselves to some extent from regulation. It's not to say that WMC or WDA or any of those industry groups wouldn't litigate the issue, but I just think that it would be a harder hill to climb, perhaps a steeper hill to climb, when they've got, multiple levels of government all weighing in on this in support. And so on this slide, I included just a cross section of karst topography to note that the water quality standards, if I recall correctly, they aren't explicit or specific to surface water quality standards. They're just water quality standards. So if you remember, water quality or waters of the state include surface and groundwater. And so I don't know, and this is me being frank, and certainly something that may require more review. There may be an opportunity to find a way to pass more strict water quality standards that address surface and groundwater under 9215. Like that is an interesting concept that I'm not sure has been explored. Both of these 92 provisions aren't necessarily things that have been touched on very often. And I think, it would be great if we could see more buy-in, more interest from local governments in testing these out, particularly because DNR and DATCAP seem willing to kind of engage in these discussions to assist where possible. I think I have one more slide on 9215 stuff. Well, maybe two, actually. Nope. All right, one more. Water quality standards examples. So one is Kewaunee County Chapter 39. And I'll note that neither of these are two caveats based on these two examples. They cite a suite of authorities. It's not just 9215. They also cite for Kewaunee County all of the statutory home rule authorities. So those are found in Wisconsin chapters 59. I want to say it's 59.22 and 59.34, which is just me trying to show off to you all that I know what I'm talking about. But they're typically meant to indicate that they have this suite of authorities. It's not exclusively the thing that's relied on. Similarly, for the town of Saratoga, that was passed in 2015, and that one cites town or village home rule authority 60.10. And in each of these instances, they sought approval, I believe, from DNR DATCAP. And at least in the town of Saratoga's, because I have that letter that DNR sent back in 2015 or 2012, they noted that DNR DATCAP only need to respond or reply or weigh in when it is a more strict standard. So what the town of Saratoga was actually doing was just wholesale adopting NR 151 and the requirements therein. So basically saying, we also want a seat at the table. We want to say that any operation in our borders, whether it be CAFOs or non-CAFOs, need to meet the standards of the spreading standards of NR 151 and by reference NRCS 590. Kewaunee County does the same thing. That's why Kewaunee County's county conservationists review all NMPs for the agricultural lands. That authority is built out of Chapter 39, and the town of Saratoga similarly is built out of one of their town ordinances. So I don't have actually any examples of the increased standards, right? Like the more stringent and requiring. I have the baseline standards that were then submitted to DNR for review and them saying we didn't need to review this. But again, all that to highlight, there are opportunities here. They haven't necessarily been historically used. And I have done a fair amount of research into them, but ultimately it's abstract or hypothetical at this point. All right. Last few slides, last kind of subsection of local ordinances, and then I will free you for the evening. So CAFO operations ordinances. This is a novel form of regulation. So as opposed to livestock facility siting out of 9390, land use management regulation ordinances out of 9211, or water quality standard local ordinances out of 9215. This is embodied entirely in what I call like local government home rule authority. And I'm not the only one that calls it that, but the home rule authority, the authority of towns or counties to protect the health, welfare, and safety of their residents. That's enshrined in some instances in the Constitution, Wisconsin's Constitution, and in some instances in statute. And this map just shows a collection of towns that kind of undertook the process in Western Wisconsin of considering, and a few of them, Trade Lake, Eureka, Bone Lake, Laketown had it for a bit, and maybe Luck has one, but I'm not sure about Luck. But a few of them at least passed operations ordinances based on that authority. For counties, that authority that's been relied on is that, like I said, that home rule authority that's put out in chapters 59, 59.03, and 59.7, as well as they cite the Wisconsin Constitution. Similarly, towns, this is both, I think I've got another slide after this. Yeah. I took these authorities from the actual ordinances that currently exist and are on the books. And to my knowledge, at least, there is no active litigation for any of these ordinances. And so the towns, I believe the town of Saratoga passed theirs based on 60.10 and 60.22. The towns of Bone Lake and Trade Lake and Eureka used 92.15 as well as maybe 61.10 as well. So all that to, and they all cite the Wisconsin Constitution. So all that to say, we're kind of piecemealing together a collection of authorities that say we can behave in this way, we can regulate in this certain way in an effort to address something that none of the other regulations cover, right? Livestock facility siting covers the siting of facilities. The local water quality standards covers specifically water quality. But what about things like, let's see, yeah, you can go down. Things like mortality management or fire plans or air emissions, or to some extent there's I believe traffic and road issues addressed in this. What about making a CAFO engage in their own environmental analysis, things like that? I've seen any of those or all of those incorporated into these operations ordinances. So their justification is we're trying to manage the day-to-day. We're not trying to manage the location of facilities or water specifically. We have a very specific thing, and those aren't covered by any of the other regulations. And it is within that niche that local governments, Bayfield County and these towns, are finding ways to regulate. So I don't have an answer for all of the ways in which an operation ordinance can create additional standards, because they haven't probably been fully fleshed out yet. What I have are examples from these 4 towns in Bayfield County, and potentially my opinion on some of them, but also I continue to look to investigate and interrogate whether there are additional opportunities. And I think the question that one needs to ask when considering this or putting this forward to their local governments are, if you want to address the operations, how does an operation of a CAFO affect us? Not how does the location of a barn affect us, but the actual operation. And what would you like to see? How can we protect the community from communicable diseases or from ponding of denser air at the bottom of valleys? Like it can be specific to every or any community, and the response can be certain limitations put in the form of permits that are granted to the operation. So it's somewhat novel, but somewhat interesting, and it's a developing area that I think we're seeing momentum start to gain traction. You can see 2016, we had 2. We had 1 town and 1 county. We had 4 between 2019 and 2022. One of them rescinded that ordinance, but we have three that have maintained, plus the former two. And I know that there are other local governments in the state that are being presented with these as opportunities and considering them going forward. So it's not a wholly fleshed out thing, but I think it's an important in a presentation like this that is just outlining the options, outlining what people can be asking their local governments for, that it be put on the suite, be put on the list of tools that folks should be aware of. And I believe that is the end of my operations, but I did just want to cite and talk about one thing really quickly, only because, and this is selfishly on my part, this comes up a lot. And I think as if I have people all here that have to listen to me speak, I'll just say one thing about this. So people bring up the right to farm law and its potential limitations on local government action and its potential limitations on WIPD's work or challenging a WIPD's permit. They bring it up in a lot of different contexts. And I just want to point out the narrowness of right to farm. Yes, it is a burdensome regulation. It is a burdensome statute, but it is specific to a finding of a court that a specific agricultural use or practice cannot be a nuisance unless that a court can't find that something is a nuisance, which is a legal term. Think like bad odor, unable to use, to go outside, things like that. If that use proceeded, so if it was agricultural before the person got to that property, and it doesn't present a threat to health or safety, right? So that's to say, like if I live next to a CAFO and it emits, it's spraying manure in a way that like I don't want to go outside, and I think that I'm being harmed by it, that seems as if it could be a nuisance action, and ultimately the right to farm law could be something that could be asserted by the other side to say like, no, you can't bring a nuisance action against me. It is specific to nuisance. It does not limit any other action. It doesn't limit any other litigation. But the reason that it has posed that it's made so much news is in Wisconsin, there's this automatic fee shifting provision where if you bring a nuisance action, the opposing side, the farm, if they win based on the right to farm law, the person that brought that lawsuit would have to pay the farm's attorney's fees. And that's the reason that it's gotten so much play. It's gotten so much notoriety or infamy. But it's, like I said, specific to nuisance. And I only bring it up because people have called us pretty regularly in the last 6 months to a year indicating, hey, if I want my local government to do this, does the right to farm law get in the way? If I want to challenge a permit, does the right to farm law get in the way? And in large part, the answer for a lot of those questions is no, because it's so specific to a specific type of legal action. And I just figured, because I had some captive ears, that I would note that, it's concerning in a very specific context, but less broad than people maybe appreciate. So I just wanted to end with that, to note, like, as you're advocating in this work, as we're all advocating in this work, don't let this be the thing that dissuades you. This is specific to something else. It's good to know about. It's good to appreciate, but it's not necessarily the thing that should limit you. All right. Final summary, not a one-size-fits-all approach. I'm happy to work with folks. Timing is critical. And like I tried to emphasize early on, collaboration, grassroots work, and coordination is so important and so powerful. And MEA is happy to be a resource for folks as they consider that. So I will say thank you. I rushed through the end. I apologize, but that was an hour and a half that I feel like I blitzed through. So hopefully you all joined me on that sprint and enjoyed what I had to say. Dean, any questions?
Yes, Adam, can you check the chat box? There are some things I think could still be addressed in there.
Sure.
And if people can't stay, that's fine. But before they leave, I just want to put a plug in for Midwest Environmental Advocates. There's a place to make a donation on their website, so give a thought to helping support the work that they're doing. And then I'll let Adam answer those chat questions.
Yeah, thanks. Really appreciate that plug, Dean. All right, so first one, an example of a success that involved an EIS, I believe, unless I didn't go back. I'll start with there, and then if I need to go back, I can. EIS work, That was specific to, I believe it was called Badgerwood. It was a proposed hog CAFO up in Bayfield County. That's, as far as I know, the last time that the DNR required a CAFO to prepare an environmental impact statement. And like I said, the DNR may have even removed the documentation off of their website. But the success wasn't in the creation of the EIS. It was that the creation of the EIS was so burdensome that they ultimately just gave up on the project. Before that, there was an EIS required in 2012 or 2014. But there was a change in the administrative codes before then, or right around then, that ultimately said that EISs for CAFOs after that point are largely discretionary on the DNR, and you have to kind of show that this is a special case to require an EIS, which is what they were able to show for Badgerwood. And I've worked on demanding an EIS for CAFOs in the past, but it's largely discretionary. It's hard to get DNR to commit to something, and you really have to point to something special. If it gets there, though, if DNR does commit to it, it does seem as though CAFOs aren't that interested in participating with that process. They'd much rather just try to cite somewhere else.
And can you tell the audience what an EIS is?
Yeah, sorry. I get too ingrained in the specifics. So, or the verbiage. So an environmental impact statement is what an EIS is. It's this aggregated document that is created by the applicant. Some people think that it's the DNR that prepares it. The DNR actually, for the most part, reviews them, but it's created by the applicant that has to basically show the entire environmental impact of the project. It's not, this is an environmental impact statement for a CAFO would be under their WIPD's permit, but they're not just addressing water discharges. They would be having to point to scientific studies and engineering reports and things on potential effects to economics, potential effects to threatened or endangered species, potential effects to air quality, potential effects to downgradient or downstream neighbors, as well as groundwater, surface water contamination. It's a really robust list. I believe it also includes things like cultural and heritage artifacts. Things like First Nations and tribal interests as well are included in EIS considerations. So it's that sheer breadth of the requirements that ultimately create this hurdle that makes it hard for CAFOs to kind of prevail on. What kind of entities own CAFOs? It's really broad. There are certainly, sometimes it depends on the region of the state. So, for example, we've seen an influx recently of major huge corporations from Iowa that are trying to move away from significant health concerns related to their herds. There are a lot of I don't know if the correct word is swine pandemics, because it's not swine flu, but it's within herds. It's pig to pig transfer that are really affecting those operations. So they're trying to move to new areas where there aren't swine operations that are currently cited. So there we see those entities. They are major corporations trying to move up. There are certainly some places. I mean, again, because the threshold is 1,000 animal units, there are some places that are at 1,000 animal units that are local individuals that have been there for a while. I can think of a few. There are also international corporations that have, if not wholesale owning CAFOs, at least have an interest, a financial interest in certain CAFOs. It's really diverse. I couldn't speak to kind of one specific type. Has there ever been a moratorium for no new CAFO permits in an area based on surface water already contaminated or impaired? So the interesting thing about moratoria is that industry will say that it needs to be that a moratorium itself needs to be based on scientific requirements. That's not necessarily the case. A moratorium needs to have a reasonable end date and a purpose. So what I'll often see is a moratorium to create a CAFO study group or to consider the need for additional regulation. It's not that you would necessarily cite the finding or the standard or the requirement in the passage of the moratorium. At least historically, that hasn't been the case. But certainly something like an impairment could support either the advocacy to a local government, or they could say like in a finding of fact at the top, and that could just give them more grounds if they needed to litigate the issue. But typically it's just that you need a reasonable length of time and a specific purpose or end goal. The difference between licensing and zoning is a really great question. So there's a case, and I don't remember both parties, but one of the parties' names is Zwiefelhofer, and it was at the Wisconsin Supreme Court. And basically, what they noted was that in that case, the county was zoning, and a town wanted to or passed a license, and the county said this license is doing the same thing or some of the same things that our zoning requirement is, and we have, we are preempting you. We get the say, you don't get the say because this is land that's kind of within both of our jurisdictions. And it went to the Wisconsin Supreme Court, and they said, no, licensing can look like zoning, but licensing is addressing certain activities or actions occurring on a land, and zoning is addressing land use for particularly like a broader area. And so it's hard to, I laugh because the Wisconsin Supreme Court has basically indicated that zoning can look like licensing in certain instances, but ultimately it's while they can coexist, it's just that licensing may be better, particularly for towns, if there is county zoning in place, because the town may be limited in what they can do zoning wise, but still have licensing as an opportunity to regulate. So they're very similar. And oftentimes, if zoning exists, licensing is just kind of the secondary option that does largely a very similar thing, but is still available to them. When would a county be required to hold a referendum if it wanted to pass a more restrictive spreading rule? It's a really interesting question. So I'm basing that, I assume, on 9211, because that's the only time I talked about the referendum. They would pass the ordinance. And the ordinance under 9211, and I don't have the language in front of me, but I believe it cannot become effective for one calendar year, essentially. And so in that time would, I believe, you would see the time in which towns would consider and hold the referendum to adopt in. But there's a lag period between a local ordinance based on 9211 passage at the county and it becoming in fact effective, and that is when the referenda would occur. Is there any movement to make stringent regulation statewide rather than individual governing entities having to do this regulating? I would love if that were the case. It is statewide regulation is really hard because our legislature, particularly over the past 10 years, has withdrawn a lot of ability of administrative agencies like the Department of Natural Resources to pass meaningful regulation. They passed what's called the RAINS Act, which is a very nuanced and highly specific statute. But basically what it says is if any regulation will cost $10 million across the state at any 2-year period, it automatically shuts down a rule, so a regulation from moving forward. And what you find is two things. One, WMC and other industry groups are really interested in putting forward economic analyses that say things like a rule based on nitrates for manure management would cost on day one of its enactment $100 million. And so like I've found, and there may be economists on this call, and I apologize for this upcoming statement, but I found that you can make economic statements say a lot of things. They can be massaged in certain ways, particularly when rules haven't come into effect yet. So you can kind of use the unknowns to your advantage. And WMC has done a very good job of doing that, and that's prevented meaningful regulation. The secondary part of the RAINS Act is that if they stop the legislature can order their own economic impact statement. And if their economic impact statement is different than the DNRs or the administrative agencies, they get to make the administrative agency pay the bill. So not only does the rulemaking go through, but suddenly that agency has to foot a bill using taxpayer money. And over the last decade or so, DNR in particular has seen a lowering of money in the biannual budgets. So they've done this thing of kind of creating laws that have prevented meaningful statewide regulation, but in a way that it's passed largely under the radar. You know offhand of any cases that ended up being a nuisance? Understand the distinction. So, two things. The nuisance cases, there have been some nuisance right to farm law cases that have come out of Iowa. I don't know of any that have come out of Wisconsin that may be interested in checking out. I can send information to Dean and he can ideally maybe forward that to the registrants of this, because they're relatively nuanced cases and they're, I think, about 10 years old. In addition to that, there is a case out of the Central Sands, which is largely at this point, it was actually brought as a trespass case, and the opposing side, the CAFO, tried to assert right to farm as a defense. And I don't think that it succeeded because they're now largely just doing settlements and payouts to the neighbors who had contaminated groundwater. So I've seen a limitation where a right to farm defense wasn't accepted in a tort action. So tort is a specific type of law that nuisance is kind of embodied in. So all that to say, there are avenues that exist. They're highly nuanced. If one is thinking about bringing a tort action, nuisance or a trespass, I would say that would require talking to an attorney to get a better grasp on it. But there's some momentum in certain areas, and I'd be happy to provide resources outside of this.
Hey, Adam, I just want to mention that Oconto County, there was an example of a nuisance case.
Okay.
That attorneys brought forward a nuisance case rather than a setback case, and they lost, and it cost.
Is that the scare gun, or no?
No, that was the B and I think it's B&D Dairy.
Okay.
So anyway, it cost the plaintiffs about $128,000 in attorney's fees. That's what the judge ruled. Well, in the end, we found them we found an attorney who would represent them, and it ended up being mostly going on the attorney's insurance, so covered it. So, but I think we have time just for one more. Robert Singers has a question there. If you can see that, let's end with that one. I know it's getting late for you and everyone else, so let's cover that one. Thank you.
Yeah. So towns in general don't have to pass a referendum for county ordinances, with the exception of 9211, which is what if a county is going to base an ordinance off of 9211, which is what we saw for Kewaunee County's Chapter 30, that specifically in state statute does require that an ordinance be passed. My only caveat to that would be that I don't know that 9211 would be necessary. Maybe there's a way to go through 9215 or some other state statute. But if a county is going to pass an ordinance through 9211, like we saw for Kewaunee County Chapter 30, that expressly requires in statute that towns have to opt into that through a referendum.
Okay, well, with that, we will close, and I will make announcement that we will have this in our weekly update. It'll be on the website, and we'll announce that on the weekly update probably next Tuesday. So thank you everyone for attending, and thank you, Adam, so much for your excellent presentation, and good luck in the future with all of your court cases that may be coming forward.
Yeah, I really appreciate it. Thanks everyone for tuning in. And again, if anyone has any questions, please reach out to MEA. I'm happy to talk.
Good night, everyone.